speak during the proceeding. We're good.
Good morning.
Yes, you got
That's right. Hi, I'm going through it. Get on the elevator.
You're a reporter. I know you're doing the business. The rules are for other people that are not this as a public viewing. If you're a reporter, use your cell phones. Make a statement with your okay? But please, no sound. You can't have buzzing in the ring going on.
Double check my phone.
County Court for Suffolk County is now open. Any session, the Honorable Kenneth Burgess Jr., Circuit Court Judge presiding.
Please be seated. Get the lay of the land. Good morning. Let's call case number 2012-1083, State of Florida versus George Zimmerman. Interested parties, please announce your presence.
Bernie Del Rione on behalf of the State of Florida.
John Guy on behalf of the State of Florida.
Angela Corey, State of Florida.
Good morning, Your Honor. Mark Romero on behalf of Mr. Zimmerman, who is seated to my left.
Thank you. Any preliminary matters we need to take up before we start the bond hearing, State?
No, sir.
Defense?
No, thank you, Your Honor.
State ready to go forward?
Yes, sir.
Defense ready to go forward?
Yes, we are, Your Honor.
You may proceed.
My motion for bond, Your Honor, I can present a quick opening, but we can also go right into some witness testimony. The opening is my client's been charged with second-degree murder by the information filed by the State Attorney's Office. The evidence that's before you today is a probable cause affidavit. I know of no other evidence that the court is presently able to consider unless the state decides to present additional evidence. If, in fact, the court is going to consider any of that probable cause affidavit, then part of my presentation will be a review of that affidavit and raising what concerns I think may exist, and the state may then respond to that. Before we get to that point, however, we do have some family witnesses that I would like to call. We had talked to you yesterday about how that would be accomplished. I believe the court has that number. Obviously, a concern reference to you yesterday and maintains through today is a concern over safety. And I'm assuming and hopeful that the process of getting hold of the witnesses can be done in a secure way.
Okay.
And I believe you have the telephone number. They are available to begin whenever you want.
However you want to begin. Do you want me to call those witnesses first?
Sure, I didn't know if the state wanted to respond to what I just said, or?
I'll be glad to respond at the end, Judge.
Great.
Okay, thank you.
If you would then call those witnesses, Your Honor. And as we're doing that, this is his code. As we're doing that, Your Honor, if I might, this is my client's current passport, the only passport that he has. It does expire May of 2012, but did want to acknowledge this and surrender to the court at this time.
Thank you. Hello, this is Judge Lester.
Hi, Judge.
Mr. O'Mara?
If I might. Ma'am, can you hear me?
I can hear you slightly.
We're
May
going to
I
put this
come
up a little
closer?
bit further, okay?
Okay.
If I might.
We got plenty of room on this. On the cord, so try that.
Let me try that. Ma'am, can you hear me?
I can hear you just in the distance. I can hear you, though.
Great, thank you. If at any time during these proceedings, you, and I ask that you tell everybody else, have problems hearing any of the questions, interrupt us. We're going to presume that everyone can hear us unless you let us know. And you're on a speakerphone, so it may be some difficulty because there's always a bit of a delay. Did you understand that?
Yes, I do.
Great. And who am I speaking to?
My name is Shelley Nicole Zimmerman.
Okay. And your relation to George Zimmerman?
I'm his wife.
Thank you. My understanding is that you have a notary public present with you. Is that true?
Yes, I do.
May I speak to him or her?
Yes, you may. 1 second. Good morning.
Morning, ma'am. Would you state your name?
Leanne Toledo.
And I'm sorry, would you spell that?
Leandra. Last name is Gallego.
Great, thank you. And are you a notary public in the state of Florida?
Yes, I am. Commission number EE 23919.
And how long is that commission number valid for?
It expires September 7th, 2014.
Great, thank you. Have you administered oaths in the past?
Yes, I have.
Okay. What I would like you to do, I understand that there are a number of witnesses present with you. Is that correct?
Correct.
We have what's called the rule of sequestration of witnesses. Basically, that means that only the witness who is testifying, I'm going to have you swear in a witness, only that witness who is on the phone testifying can be in earshot. It's an extra duty, but I asked you to take on the duty of securing the fact that all of the other witnesses are out of earshot so that they cannot hear the testimony of the witness speaking.
Okay.
Can you do that?
Yes.
Okay. So what I would like you to do is to remove everyone but Shelley Zimmerman, who first spoke to us, from being within earshot, and I'm going to ask that you further swear her in to tell the truth.
1 moment. What statement would you like me to use?
I'm going to paraphrase. I hope you know better than I do, but I think it's that identify her by name, that she swears to tell the truth, the whole truth, and nothing but the truth, so help her God.
Let me place her on this one for you. Yes, I do.
Excuse me, I'm sorry. If you can do that in a way where the court can hear you, we would appreciate it. We need to hear you give the oath.
Okay, could you state your name for the court to hear, please? Shelley Nicole Zimmerman. And do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? Yes, I do.
Inquire.
If I'm not wrong. Again, now state your name.
Shelley Zimmerman.
Okay. And how are you related to George Zimmerman?
He is my husband. I'm his wife.
And how long have you been married?
Almost 5 years this year.
And have you lived in Central Florida longer than the 5 years you've been married to George?
Yes, I have.
How long have you lived in Central Florida?
I've lived in Central Florida my entire life. I was born here.
And do you know how long George, your husband, has lived in Central Florida?
He has lived in Central Florida since probably 8 years.
And has that residence here in the state of Florida been consistent, meaning he's lived no other place but Central Florida?
Yes, that's true.
And you understand that we're here seeking a bond so that George can be released while this case is pending, correct?
Yes, I understand.
One concern is that George, Mrs. Zimmerman, appear back when this trial is called. Do you understand that concern?
I'm sorry, could you rephrase that?
Do you understand that one concern the court would have, and the reason for setting a bond, is simply to make sure that George Zimmerman comes back when he's supposed to for trial and other court proceedings?
Yes, I do.
Okay. Would you take on the affirmative obligation to this court here today to do everything that is in your power and control to guarantee the court that George will come back to court for necessary court proceedings and for trial?
Absolutely, I will.
Further, would you take on the affirmative obligation or responsibility to advise the court should you lose contact or touch with your husband, George?
Absolutely, I will.
Even though that would, in effect, be telling the court that he might be in violation of a bond condition?
Yes.
Another condition or another concern that the court would have is a bond amount. I would ask you then, realizing that one option is for the court to grant a monetary bond, if you could advise the court of your financial circumstances. So I'll ask you a couple of questions. Are you working presently?
No, I'm not.
And what do you do with your time?
I am a nursing student.
Okay. Is that sort of a full-time endeavor presently?
Yes, it is.
Okay, and how long have you been doing that?
Well, I am 4 weeks away from my graduation.
Okay. So you're not earning any income presently?
Correct.
Do you own the home that you live or lived in?
No, sir.
Other major assets that you have which you can liquidate reasonably to assist in coming up with money for a bond?
None that I know of.
I've discussed with you the pending motion to have your husband George declared indigent for cost, have I not?
Yes, you have.
And are you of any financial means where you can assist in those costs?
Not that I'm aware of.
And I understand that you do have other family members present with you, and I'll ask them more questions of them, but have you had discussions with them of at least trying to pool together some funds to accomplish a bond?
We have discussed that, trying to pull together the members of the family to scrape up anything that we possibly can.
Okay. The court may also require that George be released on certain conditions of reporting, for example, or of having a device which can identify his whereabouts. If that is a condition, will you further guarantee to the court that you will assist George in maintaining those conditions?
Yes, I will.
And would you further take on the appropriate responsibility of advising the court should he violate any of those conditions?
Absolutely, I will.
In our previous discussions, you have evidenced a concern both for your safety and that of your husband. Is that correct?
That's correct.
Is it that concern that has led you to request that this testimony be presented by telephone?
That's correct.
Are your other family members similarly concerned?
Yes, they are.
Realizing that concern, are you asking that the court, should he allow him out on bond, keep the location of his potential release point and where he would be staying strictly confidential?
Yes, I believe that needs to happen.
Realizing that additional condition to the court, will you keep in touch with the court, with myself, with the state, concerning any anticipated changes in George's location?
Yes, I will.
And again, take on the appropriate responsibility beyond that which you have as his wife to do that to the court, even though it may in effect be detrimental to George or be a violation of his condition of release.
Yes, I will.
And you are under oath, of course, as you tell the court who's listening to you, that you take on that responsibility, correct?
Absolutely, I do.
Aside from the fear, concerns that you have for George's safety and family safety, do you believe that George is a danger to the community?
No, I do not.
Do you have any concerns in that regard?
No concern whatsoever.
Take your time.
I have no further questions of this witness. Thank you.
May it please the court. Ma'am, can you hear me from there? I've got a pretty loud voice, or I can get up closer.
I can hear you. Okay.
Okay, my name is Bernie Del Rio, and just to introduce myself since we can't see each other. Let me start off at the very end. You stated that you don't believe your husband is a danger to the community. Is that correct?
That is correct.
You are aware of what he is charged with. That is second-degree murder, correct?
Yes, I'm aware of that.
And that is a crime of violence. Would you not agree?
I'm sorry, I couldn't hear that last part.
That is a crime of violence. Would you not agree?
I agree.
Okay. May I reposition myself? Sure.
Make yourself comfortable.
And ma'am, would you not agree that your husband has a prior violent history?
No, I do not agree with that.
So are you not aware when he got arrested for a violent crime in Orange County?
I'm aware of that situation.
And did that not involve him striking or in some way battering a law enforcement officer?
No.
Did you talk to him about it?
Yes, I have.
And did he tell you that he was arrested and charged with various crimes, battery a law enforcement officer, and obstructing justice?
Yes, he has informed me of those charges.
And were you aware that he was allowed to plead a misdemeanor and put in some pretrial intervention program?
I am aware of that.
Did you ever read the actual arrest docket to that charge, ma'am?
No.
And were you aware that he was at a place when he was asked when they were actually trying to do something to somebody else. And, Your Honor, for the record, I would like to introduce that into evidence, if I may, since I'm going to be referring to it.
Defense.
You gotta provide-
It's certainly hearsay, Your Honor, though I understand that there's a certain limitation. I haven't seen it yet, so I'd like to have an opportunity to review it.
Take a look at it.
And then I'll look forward to an examination in this regard.
Be admitted, State's Exhibit 1.
Ma'am, I provided the actual arrest document to the court and also to defense counsel, but I want to read to you a pertinent part. It states, the officer in the affidavit, the arrest warrants, or I'm sorry, the actual arrest document states, I identified myself as a state police officer and showed Zimmerman my badge and asked him to leave the area. He stated, I don't care who you are. I again asked Zimmerman to leave. He then stated the F word, and he said you. And at that time, I attempted to escort Zimmerman away from the interview room. He shrugged away from me and then pushed my arms away from with his hands. After a short struggle with Zimmerman, he was placed in handcuffs and detained. Did you discuss that matter with your husband, ma'am?
Yes, I did.
And did he tell you it was just a misunderstanding or an accident?
No, he didn't say it was an accident.
So he admitted that he had struck a police officer when the police officer told him to abide by his commands.
The
Correct?
police officer did not identify himself.
Okay. But you would agree that that which shows that, and I believe the year of that was 2005, you would agree that that shows prior violence on the part of Mr. Zimmerman, your husband?
No, I don't.
Okay. And were you also aware of a prior incident that Mr. Zimmerman had in which a lady by the name of Veronica, and her last name is Zuzu, and I'll misspell it for the court, I'll probably butcher it, Z-U-A-Z-O, a prior lady that he was dating, where she filed an injunction against Mr. Zimmerman because of his violence?
I'm aware of the injunction.
Okay, and were you aware that in that injunction, and Your Honor, I would also, at this point, since I'm going to be referring to it, tender that injunction to the court.
Does the defense?
Same objection, Your Honor. It seems to be both distant in time and certainly hearsay.
Madam Clerk. Can you do this other one tomorrow?
And you're aware that in that, I apologize, Mayor, if you want.
Sure. I was going to say Zwazo is how I was going to say it.
Yes, sir. Were you aware that, so Mr. Zimmerman told you about that incident with Ms. Plaza?
Yes, he did.
In which she alleged in this affidavit that he, Mr. Zimmerman, pushed her, and then he, with his open hands, snapped her in the mouth and asked her how it felt?
No, I'm not aware of that.
Okay. He then, and I'm sorry, I'm referring, the court will have time, I can read the whole thing, but since the court has it, I'm just going to refer to parts of it if I could. He picked me up and threw me on the bed, got up to leave, and he grabbed me again and put her on the bed. You weren't aware of that incident?
I'm aware that he had to protect himself from being attacked by her, and that there was blood drawn on him from her, and he also filed an injunction against her.
That is correct. He did file an injunction against her, correct?
That is correct.
Okay. Now, so despite those two incidents, the prior arrest involving a law enforcement officer and the incident involving the injunction, you would still assess or determine or tell the court that he is not a violent person nor a threat to the community?
Absolutely, he is not a violent person nor a threat to the community.
All right. Let me then start at the very beginning of your testimony. You stated that you had been married for how long with Mr. Zimmerman?
I'll be married for 5 years in November.
Okay. And did you all live at the residence in the townhomes where this murder occurred? Did you live together with him at the townhomes where this occurred?
Yes, I did.
Okay. And was that the entire 5 years?
No, that was for about 3 years of that, 2 to 3 years.
Okay. And the reason I asked that because you stated that you all did not own that home?
That's correct.
Who owned the home?
Our landlord?
Okay, so you all rented?
Yes.
Okay. And were you working any of those 5 years, or were you going to nursing school the entire time?
I was working for the first year.
Okay. And your husband, the defendant, Mr. Zimmerman, was also working during that entire time?
Not the entire time.
Okay. How did you all support yourselves when both of you were not working?
When we were not working, we collected unemployment benefits.
Are you still collecting unemployment benefits?
No, sir.
And is Mr. Zimmerman, your husband, collecting unemployment benefits?
No, sir.
Now, I think you stated you are from Central Florida. You grew up here, correct?
Yes.
Okay. And you mentioned also in terms of the ability of your husband to make the bond amount that you all had no money. Is that correct?
To my knowledge, that's correct.
Okay. Were you aware of the website that Mr. Zimmerman or somebody on his behalf created?
I'm aware of that website.
And how much money is in that website right now? How much money, as a result of that website, was?
Currently, I do not know.
Who would know that?
That would be my brother-in-law.
And is he in? I don't know. I know he's not in the same room as you, but is he available so we can speak to him too, or the court can inquire through the state or the defense?
I'm sure that we could probably get him on the phone.
Okay, so he's not there now.
No, he is not, sir.
Do you have any estimate as to how much money has already been obtained?
I do not.
Okay. You haven't talked to your brother-in-law in terms of this bare amount of how much money?
No. No, I have not.
And how long has that website been in existence, ma'am?
I do not know. I have not been with my husband since he's been in hiding. I do not know.
Okay. So you mentioned your husband was in hiding. I understand that you left the state. Is that correct?
That's correct.
Okay. Did you continue to have contact with him while he was out?
Yes, every day.
And that was every day?
Yes.
Okay. And were you aware that the police or Florida Department of Law Enforcement was monitoring you at that time?
Yes.
Okay. So when you say he was in hiding, he was actually, in some ways, being observed by members of law enforcement, correct?
Yes.
Okay. For his safety too, correct?
I'm sorry, say that again?
For your husband's safety too?
Absolutely.
Okay. You also mentioned that you yourself were concerned about your safety, is that correct?
Yes, I am.
Have you yourself personally been threatened by anybody?
Anything that happens to my husband is a personal threat to me.
Yes, ma'am. I don't mean to argue with you, but you yourself have not been threatened, is that correct?
I have received hate mail.
Okay. And have you reported that to the police?
No, I haven't.
Have you reported that to my boss, Ms. Corey, the state attorney's office, so that somebody can investigate it?
No, sir.
Did you keep those threats?
I'm sorry?
Did you keep that hate mail?
Yes.
Do you have that available where you can turn it over to your attorney?
I'm sure I can.
And there's a difference between hate mail and threats. Was there any threats in that hate mail?
No, sir.
Okay. That was only on your time. I have no further questions.
Thank you, Your Honor, if I might inquire. Mr. Zimmerman, can you hear me?
Yes, I
Let's
can.
spend a couple of minutes about what you were told by George regarding the event where he was arrested for battery on a law enforcement officer. He did discuss that with you?
Yes, he did.
And didn't he tell you that he approached people who were
Objection
sitting
leading.
on the...
Objection leading. I know it's motion.
No, it was entered into an open, I would suggest, by the
Go ahead.
prosecutor.
Sustain. Go ahead. Keep going.
What did he tell you as to why he approached the people who are being detained by law enforcement?
He told me that it was a friend of his that was being shoved up against a wall by a man in regular street clothes that was, he felt that his friend was in danger and he was just trying to protect his friend.
And did he give you any indication as to any potential injury he thought was happening to George's friend that he went to protect?
I'm sorry,
Did he tell you about any injuries that he saw or was concerned about?
I'm not sure of any injuries. I don't remember.
Okay. So he approached a friend of his, and did he tell you what law enforcement first said to him?
I don't remember.
Did he tell you, or give you any indication how law enforcement reacted to his concern over his friend?
they just pushed him aside and said, "Get out of here."
Did he give you any indication as to whether or not law enforcement during that event identified themselves as law enforcement?
No, they did not.
Now, the law enforcement officer's sworn statement says that he did. Did Mr. Zimmerman tell you anything about that?
He just said that that's not true, that they did not identify themselves, or else he would have never done anything.
Okay. Now, they arrested him that night, did they not?
They did.
They charged him with a couple of felonies, battery on a law enforcement officer, and resisting arrest without violence, homicide, obstruction of justice. Did they not?
They did.
Okay. After having been arrested for that felony, do you know how the case was resolved?
I know that he did a pretrial diversion.
Okay. So, in effect, from that event, suggested to be a violent event, what the state actually did was let him plead to
Objection, is this a question or?
It's going to be. They let him plead to a misdemeanor and go into pretrial diversion. Is that your testimony?
Yes, it is.
And do you know what he had to do as conditions of that pretrial diversion?
I believe he had to go to anger management.
And do you have any indication that he didn't successfully complete that?
No, I don't.
Do you have any indication that he didn't successfully complete the entirety of his misdemeanor pretrial diversion?
Say that one more time, you're
Do you
breaking
have
up.
any indication that he did not successfully complete his misdemeanor pretrial diversion?
No, he didn't.
Let's speak then for a moment about the injunctions referenced by the prosecutor a few minutes ago. You had said something about your insight as to what George had done in response to the injunction. What was that?
That Ms. Zuazu didn't want him to go out that night, and she scratched him and drew blood on him and started attacking him, and he picked her up and put her on the couch and protected himself from her.
Okay. And, matter of fact, the injunction even references that she called 911 and advised them of that, correct?
That's correct.
And now that it's in evidence, the 911 operator, do you have any indications that the 911 operator suggested that they would send out law enforcement for any crime?
I'm not sure.
Was George ever arrested for any crime?
No, he was not.
And what, you had testified that he had gotten an injunction against her. Do you know if that was granted?
I believe that was granted, yes.
Just a moment, if I might. Thank you, Your Honor. Anything further this morning?
State?
Yes, just one or two questions, Your Honor, if I may. Ms. Zimmerman, I was curious, you mentioned that he had to go through anger management?
I believe so.
Okay, and you stated you believe that he was successful in completing that?
Yes.
Okay, and I gather my follow-up question regarding that is, have you ever seen him angry, or do you think he has problems? Let me ask first thing, have you ever seen him angry?
No, I haven't.
Okay, so you don't think he has anger management problems, is that correct?
No, I do not.
Thank you, no further questions.
Could this witness be released? Defense?
Yes, Your Honor.
State?
Yes, sir.
Thank you, ma'am. You're released. You may call your next witness.
I would call Robert Zimmerman, Sr.
Robert Zimmerman.
Senior?
One moment. Hello?
Good morning. So will you state your name, please?
Robert
And how are you related to George Zimmerman?
I'm his father.
Great. What we're going to do is we're going to have you testify, but first you'll need to be placed under oath by the notary. The requirement is that only you are with the notary and are testifying. Nobody else can hear you, so please be certain that nobody else is in earshot of your testimony, and then let us speak to the notary for a moment who will place you under oath.
Yes.
Hello?
Ma'am, if you would, place Mr. Zimmerman, Robert Zimmerman, under oath so we can have testimony from him.
Robert Zimmerman, are you sound mind? You swear to tell the truth, the whole truth, nothing but the truth? Yes, you got it.
Yes, I do.
Good afternoon. Good morning. State your name again, sir.
Robert Zimmerman.
And your relationship to George Zimmerman.
I'm his father.
Okay. And over the past several years, what type of contact have you had with George?
Well, we've lived in Florida for a little over 5 years, and we've maintained fairly close contact with him.
And you understand that he is presently before Judge Lester in this case where he's being charged with second-degree murder, correct?
Yes, sir.
And that we are seeking to have him released on bond.
I'm sorry, sir?
And that we are seeking to have him released on bond. Are you aware of that?
Yes, sir.
Some of those conditions, as I mentioned to your daughter-in-law, Shelley, would be a requirement that George appear at all necessary court proceedings and at trial. Would you take on the affirmative responsibility of assuring the court that you will assist George in doing just that?
Absolutely.
Would you even take on the affirmative responsibility to advise the court and the state were he to fail to maintain all of his conditions of bond?
Absolutely.
So, for example, if one condition were that he stay in a location or that he maintain counseling, and if he failed to do that, would you advise the state and the court?
Yes, I would.
Though it may lead to a violation of that bond condition against your son, and may even lead to his re-incarceration.
Yes.
Another issue that needs to be considered by the judge is the financial means that George, and to a certain extent his family, has available to him. How can you assist financially in securing a bond for George's release?
Well, I'm a disabled veteran and don't have a great deal of income. My wife is retired. We have some savings, but very little.
Thank you. Do you have any major assets? For example, a home that you live in?
We have a home. We have a mortgage on the home.
If a condition of his release were to be that you might need to secure that home such that you couldn't sell it during the time that George is released, and that any equity that might exist in that home would be secured to be surrendered to a bail bondsman if he failed to appear. Would you take on that responsibility?
Yes, sir.
In effect, would you take on what we might call a second mortgage against your home to secure George's release?
Yes, sir.
There has been concern about the question over whether or not George is a violent person. Do you believe that your son is a violent person?
Absolutely not.
And if you could expound on that.
Well, I've never known him to be violent at all unless he was provoked, and then he would turn the other cheek.
Any concerns with your safety around George, for example?
No, none whatsoever.
Do you have a concern for your own safety based upon the emotions that exist in this case?
Absolutely.
you're asking the court then to maintain, if he's released on bond, secrecy around any locations of both family members and George.
Yes, sir, absolutely.
And with that additional request for anonymity, will you further take on the responsibility to keep the court, the state, and me aware of George's whereabouts and what he's doing?
Yes, I will.
And you are the oath, so the court is both listening to you and is potentially relying on that commitment. So is it sincere and undeniable?
Absolutely.
Please report. Good morning, Mr. Zimmerman.
Good morning.
I've never met you before, so let me, if I could, introduce myself. My name is Bernie Del Rio. I'm the Assistant State Attorney. You mentioned that you all have no resources in terms of helping your son out. Do you know if Mr. Zimmerman, your son, had a car?
I know he has a car.
Do you know if that was owned freely or if he owed money on it? Or
I don't know. I would guess that it's being financed, but I have no idea.
And how about your daughter-in-law? Does she have a car?
She does.
Do you know if that's money owed on that or not?
I know there was money owed on it. I don't know currently.
Yes, sir. You also mentioned that you felt your son was not a violent person. Is that correct?
Absolutely.
In fact, if I wrote it correctly, you said that you've never seen him be violent, and unless he's provoked, and even then you said he would turn the other cheek. Is that correct?
That's correct.
Okay. You are obviously aware of what he's charged with in terms of murder, correct?
Yeah.
And you were not a witness there, I'm assuming, correct?
I'm sorry?
You weren't there to see what happened, correct?
No, I was not.
Okay. But you are aware of his prior arrests involving violence, are you not?
I knew of an incident involving alcoholic beverage control officers in plain clothes.
Right. And in terms of your background, were you not a magistrate somewhere, not in the state of Florida, but in Virginia or Maryland or somewhere?
Yes, I was.
Okay. So did you discuss this matter of his prior arrest with your son?
Yes, I did.
Okay. And did he tell you in that particular case he turned the other cheek?
Well, he did. He did. A friend of his was grabbed and thrown up against a wall by some people in civilian clothes.
Yes, sir. And did he tell you that they asked him to leave and he told them, I don't care who you are, when the officer identified himself as a law enforcement officer?
No.
Did you ever read the actual arrest document?
No, I did not.
Were you not curious, having been a magistrate, in terms of whether your son was telling you the truth or just for curiosity's sake?
I've never questioned whether or not my son was telling me the truth.
So you just believed him because of your son?
No, I believe him because he's been honest his whole life.
Okay. Did you go to any proceedings involving that arrest, sir?
No, I did not.
And were you aware that he was put in a pretrial intervention program and specifically given anger management classes?
Yes.
And did you go to any of those anger management classes with him, sir?
No, I did not.
Did you ask him about that, how he did, whether he passed, failed, or how long they were for?
No.
Okay. Do you believe he has an anger management problem?
No, I do not.
Okay. I'm assuming, aside from being his father, obviously, and being a magistrate, you told him the importance of the law, did you not?
I'm sorry?
You told him the importance of the law, following the law? And you're raising your son, you stressed to him how important it was to follow the law?
Yes.
Okay. And in terms of calling police if there's a need for help, correct?
Yes.
And not to assume things, not to assume that people are committing crimes when they may or may not be. Let me rephrase that, I apologize. Did he, your son, at one time want to be a police officer?
He's always been interested in criminal justice.
Okay. And did you ever have discussions with him in terms of arrest powers, civilians versus police officers, etc.? I haven't been a magistrate.
Not that I recall.
Did he ever inquire you in terms of what laws there were in terms of self-defense or arresting people or following people, that kind of stuff?
No, sir.
Okay. And were you aware that he was involved in the neighborhood watch program, sir?
Yes, I was.
Okay. And did you know that those neighborhood watches, in terms of procedures, they tell people not to follow people?
Well, when they are performing neighborhood watch, that's correct.
And I apologize. You were not involved in that neighborhood watch in that particular area where your son lived. Is that correct?
No.
Did you mention that your son did go to college? I believe he was in his second year of college.
I believe he was in his third, but yes.
Okay. And he was a criminal justice major?
Yes, sir.
Okay. And were you aware of this lady who he had a problem with, or at some point she filed an injunction against him and he filed an injunction against her? Were you aware of that? Do you know anything about that incident itself?
No, I don't.
Okay. Did you ever talk to your son about the incident?
No, I haven't.
And, sir, one other area I want to talk to you. You're aware that the website has been created for your son?
Yes.
Okay. Are you involved in that at all?
No, I'm not.
Are you aware of how much money has been collected up to this point?
I have no idea.
And to your knowledge, who's in charge of that program or that website?
I'm not sure.
And so you have no idea, like, where the money's going or where it's being deposited, et cetera?
I have no idea if there's any money, how much money, or who has access to it.
Okay. Do you know if your son has any kind of medical condition in terms of a drug problem? I'm not saying he does, but are you aware of any kind of medical history that would interfere with him being able to function out in society?
No.
Okay, he has no kind of, I'm not implying that it is, but I want to make sure he doesn't have any kind of mental problems, correct?
Well, I've had fairly limited contact with my son since his head was beaten, so I can't say now.
I'm talking about, and you were there when his head was beaten, allegedly?
No, I saw the scars on the back of his head and his face swollen and everything the next morning.
You did? Where did you see him?
At his house.
Okay. And so he told you about what had happened?
Yes, he did.
Okay. But I was inquiring prior to that in terms of whether he had kind of any psychiatric history or anything.
No.
Okay. About that. May I have a moment?
Take your time.
I have no further questions on it. Thank you.
Mike, Mr. Zimmerman, it's Mark O'Mara again. Did George ever talk to you about why he had gone into criminal justice?
Well, at one point he said sometime in his life he'd like to be a magistrate or a judge.
Did he talk to you about becoming a lawyer?
No, he didn't.
So he sort of, as he discussed it with you, wanted to, in effect, follow in his father's footsteps. Would that be accurate?
Well, he's always been concerned about people in society, so he wanted to be able to help somehow.
So what did George's head look like when you saw it the day after?
Well, his face was swollen quite a bit. He had a protective cover over his nose. His lip was swollen and cut. And there were two vertical gashes on the back of his head.
You seen pictures of that?
I'm sorry, sir?
Have you seen any pictures of that?
I did not take any pictures.
Have you seen any of them?
Yes, I have.
Who showed them to you?
I saw one on the news today.
Did state attorney's office ever show you any of those pictures?
No, they did not.
Did they ever talk to you?
I spoke to the state's attorney's office briefly in Sanford.
How long after the event?
I don't recall the date. It was right after the state's attorney took over the case.
Right after Ms. Corey took over the case. The new state attorney?
The state attorney in Sanford.
At that point, did they show you any of the pictures similar to the injuries that you had seen that night?
No, they did not show me any pictures.
The next day?
No, they did not show me any pictures.
No questions, Your Honor.
Excused defense?
Yes, Your Honor.
Yes, sir.
Thank you, sir. You're excused. You may call your next witness.
Oh, my client's mother, Your Honor, Gladys Zimmerman.
Gladys Zimmerman, please.
Gladys.
Hello.
Good morning, ma'am. Would you state your name, please?
Gladys Zimmerman.
And how are you related to George Zimmerman?
I'm his mother.
Okay. A couple of initial comments. One, the notary public who should be there with you is going to place you under oath, swear you to tell the truth, so that everything that you say after that forward is going to be what we call a sworn statement or a statement under oath, and it must be the truth. Do you understand that?
Yes, sir.
Additionally, if we speak and you can't understand us, I want you to make sure that you interrupt us to let us know that you can't understand us, correct?
Yes, sir.
Okay. Then if I may speak to the notary public for a moment.
Yes, sir. When is swearing now? Gladys Zimmerman, are you 18? Yes, I do.
Did you hear that, Your Honor?
I did check if there's anybody else in the room.
Hello.
Okay, now, as per a previous rule, there should only now be you and the notary public within earshot. So is anyone else nearby?
Excuse me?
Is anybody else with you besides the notary?
No, nobody.
Great, thank you. Then again, if you would state your name.
Gladys Zimmerman.
And you are George's mother, correct?
Yes, sir.
And you know that he's here before the court being charged with second-degree murder, correct?
Yes, sir.
And that we are presently asking the court to allow him out on bond.
Yes, sir.
A couple of questions. What type of contact have you had with George over the past few years?
Hello?
Yes. Let me ask it. Do you stay in pretty frequent contact with your son George and his wife, Shelley?
Yes, sir.
Okay.
Yes, sir.
And do you know where he lived?
Yes, sir. He, as a matter of fact,
Okay.
we picked the place where he's
Okay,
living.
I didn't want to hear that, quite honestly. But do you have any concern for George's safety upon release?
As a matter, yes, I do.
Are you
I do because we have received a lot of threats.
based upon those threats or concerns, are you asking that the court maintain a secrecy or confidentiality over where George may be released and where he's allowed to go?
Absolutely.
I'd asked your husband some of these questions, so I'm going to go through them quickly, but one condition the court has to consider is financial ability to pay a bond. And if I might just lead it through it for a moment. Your husband testified that you're retired, that he's a disabled veteran, and you do not have much savings. Is that correct?
Yes, sir. That's correct.
But you do have a house that you own, correct?
Yes, yes, sir.
And that there is some equity in that home. Is that also correct?
Yes, sir.
Do you have any idea about the amount of equity that exists in that home?
No, no, sir.
Whatever it may be, would you be willing to pledge that in some form or fashion to secure George's release, realizing that you could lose it if George does not come back to trial? You would be willing to do so?
Yes, sir.
The court also has to, in effect, trust that George will return for court hearings and for trial should he be released. Would you take on the affirmative obligation to advise the state attorney's office, the court, myself, should you find out that George has violated any conditions that may be given by the court?
Yes, sir. Hello?
We're
Just
still
one
here.
moment.
We're still here.
Okay.
Ms. Zimmerman, there's been testimony concerning George's history and suggestions that he's had violent evidences in his past. I want to ask you about some of those. Did he discuss with you his arrest at the hands of alcohol, firearm, and tobacco officers?
Yes, he did.
Okay.
That was a long time ago.
And what did he tell you about that?
He told me that he was with a friend, and this friend was pushed around by a civilian people, and he tried to find out what was going on, and he was pushed around, and they told him to move, to get out, and George wanted to defend his friend.
Is that something that you've come to know about George, that he will go to the defense of others?
Yes, sir.
How has that shown up to you?
That particular case, or you want to mention another case?
Other cases?
Another case?
Yes, since the issue of his violence is at hand.
For example, when in 2010, he saw, well, he didn't saw, but he found out that a homeless person was being beaten by another man in the city of Sanford. He organized the whole community. He went to churches. He put flyers on cars. He did everything possible. So the city of Sanford will organize and go to the council and ask for justice for this homeless man who was beating up.
And that was at George's insistence?
Yes, sir. That was George. That was my son. And there are probably tapes in the Sanford council when he went and organized a meeting so that poor man could have justice.
Any other
In fact, he
indication?
was recognized also by the mayor.
Sanford's mayor recognized him for his efforts in that regard?
Yes, sir. I believe so.
In addition to that event, any other things that come to mind of how George seemed to come to the defense of others?
Another case?
If you know of any.
On the top of my mind, no, I don't know. But I know that he is very protective of people, very protective of homeless people, and very protective also of children, no matter the race, because he was very active. He was a mentor for a boy in the city of Orlando.
Tell me about that.
This program started like 2 years ago, and when the program started, you have to be committed to the program. So you have to go to classes, and you have to sign like a contract that you will keep on with the program. When the program he signed the program, and because of the economy and the crisis that we are in the economy, the program was closed after 9 months. But George continued with the program. He continued the whole year, and after that year, he kept on with the program for
this was his second year going on to the city of Orlando and taking care of, a matter of fact, 2 kids, because his wife also mentored the sister of the young boy that my son mentors. So the couple mentored these 2 kids for the last 2 years.
And how old are those children?
I believe one is, and the other one is 14. The boy is 14. And I had met him. They are very nice kids. George tries his best to give them love and teach them, and keep them in good manners. They are very lovely kids, and they love so much George, because George used to go to see them every 2 weeks, twice a month. He will go and see them. And I had begged George not to go. I'm sorry. But I had told my son, please don't go. It's too dangerous. And he said, Mom, if I don't go, they don't have nobody.
Why were you concerned about George's safety within that program?
Because it's a very dangerous place where he goes to.
A very bad what?
Dangerous place.
A bad news place?
Dangerous place.
Dangerous place.
I'm sorry. My apologies.
That's okay.
What was the racial background of the 2 children that he mentored?
African American, sir.
Nothing further, Your Honor.
Good morning.
Good morning, sir.
I'm Bernie Delary on behalf of the state of Florida, since you can see. I just have a few quick questions, hopefully. You mentioned that he likes to defend other people, correct?
He tries to protect people.
Right. And you are aware about his prior case in which he was arrested, right?
I'm sorry.
I apologize. I turned my back. I apologize, Mr. Zimmerman. You were aware of the prior case in which he was arrested, were you not?
Yes, sir. That was in 2005.
Right. And that was in 2005. Did you talk to your son about that?
No, lately. Then, yes.
Okay. And would you say your son, from an authority standpoint, if a law enforcement tells him something, he'll abide by it, he'll follow directions or orders?
Yes, he will.
Okay. Do you know why the arrest docket, when the officer identified him and stated to leave the area, he did not?
For what George told me, that police officer never identified himself as a police officer.
Did he also claim regarding the, I apologize, did he, your son, claim regarding that incident that he was defending himself to?
I'm sorry?
Did he say regarding that arrest incident in 2005 regarding those officers, did he say Mr. Zimmerman say, your son, say he was defending himself?
I don't recall that, sir.
Okay. And you don't have any knowledge of the website, do you, in terms of the money?
No. I know I have seen the letter, but I don't have any access to it.
Okay. Thank you very much, ma'am.
You're welcome.
Thank you, Your Honor, for the questions. If I can have just...
Excuse?
Yes, Your Honor.
Yes, Your Honor.
Thank you, ma'am. You're excused.
I don't have a moment.
Take your time.
Hello?
We're still here.
Okay. Did you need to speak with another witness?
We're going to wait a second and see what's going on.
Okay.
I'm done with the witnesses on the telephone, Your Honor. We could end that conversation.
Okay.
But I do need a moment.
Okay, thank you. Ma'am, we're finished. Okay?
Okay, great. Thank you very much.
But if I might still just have a moment.
Yes, sir.
Nothing further at this point of the presentation, Your Honor. No further witnesses.
State.
We have no witnesses, Your Honor.
To the extent that they're going to ask you to rely on the probable cause affidavit, I do have some inquiries concerning it. I would like to have the opportunity to do so if, in fact, they're going to ask you to rely on it. And I don't know of any other evidence that they have in the court file besides the fact that they filed an information that there's a probable cause affidavit.
Your motion, you argue it.
Thank you. Do you have the probable cause affidavit available to you? My concern, and the reason why I ask it at this point, is it's certainly going to become argument rather than a pure presentation of evidence unless the state has either of the two officers who signed this affidavit available.
They're available.
It would probably be more direct and more proper if I examined that witness. So I would call...
I don't mean to be rude to you, Mr. Romero. It's your motion. You argue it however you think is best for you. Okay?
Thank you.
Okay.
Then I would call either Investigator T.C. Osteen or Investigator Dale Gilbreth.
Thank you. Investigator Gilbert.
Just say, Mr. Gilbert, stand here, please. Please one minute.
Please tell me where from this testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God.
Investigator, once you're seated, if you would please state your full name for the record and spell your last name.
My name is Dale Gilbreth. That's Gilbreath.
May inquire.
Morning, sir. State your occupation, if you would.
An investigator with the State's Attorney's Office in the 4th Judicial Circuit.
And my understanding is that you are one of the investigators on this case, correct?
Yes.
Would you consider yourself one of the two lead investigators? How do you determine your involvement, or how do you define your involvement?
I'm one of the two investigators working on the case with the State's Attorney's Office after it was assigned.
And did I note a file that you brought up with you? Did you bring a file with you?
No, sir. I brought a copy of the...
Oh, I'm sorry. It was that. I thought you brought something up with you. Do you have anything besides what you just identified, a copy of the probable cause affidavit?
No reports or anything, no.
Bring any supporting documentation with you to the courtroom on his bond motion at all?
No, I was not planning on testifying. Okay.
But you do have the probable cause affidavit, correct?
I have a copy.
I would like to spend a few minutes going over that with you, if I might. And I'm going to try and make it easy for us, with the court's indulgence, to use a blow-up of it, so that we can talk about this. Can you see that?
Yes.
Take a moment just to compare the two to make sure that that is, in fact, the affidavit that you're reviewing. May I examine the witness from the exhibit, Your Honor?
Whatever you're most comfortable with.
That seemed to be the affidavit. I'll show you the second page when we get to it.
It appears to be, yes.
If at any time during this examination you're concerned that the probable cause affidavit that you have is different than the one I'm examining you from, let me know if you would, okay? Great. It starts out with 2 or 3 paragraphs. I'm dropping stuff everywhere, excuse me. 2 or 3 paragraphs, sort of prefatory, telling the magistrate, the judge who you want to follow this affidavit, who you are and what you do, correct?
Yes.
And you and a fellow officer tell us that you're officers, you're investigators, correct?
Yes.
Done it for 35 years.
Yes.
And you've taken sworn statements. Up here, there's no evidence, correct? This isn't evidence for the court to consider beyond what your background is?
Yes.
What I'm going to call substantive evidence. So let's use that as a determination, meaning by that, evidence that relates to the facts of the case, okay?
Okay.
Great. So this, we would not consider this evidence, would we? Substantive evidence?
No.
Okay. And the fact that you took statements, certainly the statements would be evidence, but this is not evidence, correct? The fact that you took them isn't substantive evidence, is it?
The fact that they were taken, no, they're not.
Okay. Then you say Sunday, 2/26, Trayvon Martin was temporarily residing at the retreat at Twin Lakes, Sanford, Florida. Certainly a piece of evidence, substantive, tells us where Trayvon Martin was living, correct? Yes. Doesn't give us any indication as to what happened, though, correct? With the eventual event that led to Trayvon's death, correct? Just tells us where he's living.
Correct.
Okay. That he had iced tea and a bag of Skittles. That he walked back and entered the gated community. Was on his way back when he was profiled by George Zimmerman. If I say to you the word peanut butter and, what do you think?
Jelly.
Okay. Mo, Larry, and?
Curly.
Okay. When I say the word profiling, what do you think?
I believe you're applying a predetermined thought pattern to a set of circumstances.
No other word comes to mind when I say the word profiled to you?
I gave you my answer, sir.
Okay, I appreciate the answer. Did you consider it to be some specific type of profiling?
No.
Then why'd you use the word profiling rather than noticed, observed, saw, or anything besides the very precise word profiled? And by the way, was that your word? Did you come up with that word?
I don't recall. This was a collaborative a collaborative document.
Between who, in addition to the two people who signed it as being true?
Detective Osteen and I prepared a good majority of this. It was reviewed by our supervisor, Bernie Del Rionda. There were several mistakes in it that were corrected, and this was the final document.
Do you know whose word profiling was?
No, I do not.
When you swore that to be true, what did you mean that to indicate?
That Zimmerman saw Martin, formed an idea in his head, and contacted the Sanford Police Department with no facts.
With no facts. And of course, you have available to you Mr. Zimmerman's statements, correct?
Oh, I do.
Again, you say that he lived in the gated community, driving his vehicle. Zimmerman felt that Martin did not belong in the gated community and called the police. Do you get that from your conversations with Mr. Zimmerman?
I have never spoken to him.
From his sworn statements that were given?
From those, his 911, his non-emergency dispatcher.
And you state that Mr. Zimmerman perceived that Trayvon Martin was acting suspicious, correct? Did he give you, do his statements give us any insight into that?
When talking to the police dispatcher, I believe he indicated that he was suspicious.
Okay. Did he use that word?
Without reviewing it right now and reviewing all the stuff we have, I can't honestly say if he used that word during the dispatch tape.
And the police dispatcher informed Zimmerman, that an officer was on the way and to wait for the officer, correct? And
I believe so.
You would have gotten that from the 911 tape that has been heard?
The non-emergency tape, yes.
Non-emergency, sorry. Now, I'm curious, you then say, during the recording, Zimmerman made a reference to people people he felt had committed and gotten away with break-ins in the neighborhood. What was that gave you that indication, do you recall?
I think he said that the second line that before you stopped, part of that is included in that statement.
How many different statements existed, the non-emergency, the emergency, how many phone calls existed of George Zimmerman's communications with law enforcement?
That, on this evening?
Yes.
I believe one.
Okay. Was it your determination or decision to put in quotes, thereby suggesting it's his words precisely? And the only quotes you use, two phrases that use expletives. Was that an affirmative decision by you?
I don't disagree with it, but I'm not the one that put the quote marks on. Why don't I disagree with it? Why did I do it?
No, why'd you do it?
I didn't type this.
Well, you swore to it.
True, but I did not type it.
Okay. Did someone else make the decision to put in 2 quotes, and the only 2 quotes, that suggest that my client was using expletives?
I don't know the decision-making process to put those in quotes, but as far as I recall, those were the quotes.
Absolutely true. Don't deny that they were quotes. I'm just curious why all of the other sentences that he did, all the other questions that he had, everything else that he did, why those didn't make it into quotes for a probable cause affidavit. And since you signed it, I'm curious if you can give us any insight on that.
Well, I answered that. I didn't put them in quotes. I can't give you insight into that.
But that's your signature.
I agree with that. That is my
So
signature.
you swear this is true.
I don't believe those statements are untrue.
But you don't know who made the decision to solely put those 2 phrases in quotes.
No.
Right? Okay. Who was in this decision-making process?
As I said, Detective Osteen, myself, and Bernie De La Rionda.
During this time, Martin was on the phone with a friend and described to her what was happening. And how did you get that information?
From Detective Osteen.
Okay. And how did he get it?
He interviewed the witness.
And Bernie?
No, I don't.
You don't know it?
I do. I have access to it.
I apologize. I'm going to object as to that witness's name being disclosed
And
for
I
her safety.
apologize. It came out, and I realized our agreement, and I apologize.
You know who the witness is, and you know what the name is, you just don't want to reveal it at this time pursuant to court order.
Yes, sir, and I have access to it. However, I do not.
That's fine, and I apologize for the slip in the inquiry. How long after the event was that witness spoken to?
$5 weeks
5 weeks.
by Detective Osteen.
First time she was spoken to by anyone revolving this case, as far as you're aware?
I have no other knowledge other than when Osteen spoke to her.
And having had a chance to review those statements of this witness, you cannot present to us today that she had any conversations with anyone else about this event until Osteen talked to her, correct?
Correct.
Any reason why it took 5 weeks?
I have no answer because I was not involved in that interview.
She told you that Trayvon Martin was scared because he was being followed by an unknown man and didn't know why, correct? I'm sorry, I'll just back it up. He told Osteen, and you've reviewed the affidavit, correct?
I've reviewed this affidavit.
Did you review her sworn statement?
No.
Now, these are your words, so tell me when they're truly not. But the sentence says, Martin attempted to run home, but was followed by Zimmerman, who didn't want the person he falsely assumed was going to commit a crime to get away before police arrived. Where did you get that second half of that sentence from? I mean,
I believe that paragraph comes from Osteen's interview with the witness.
No. Let's look at it again together. This is what the witness said. This part of the sentence right here, followed by Zimmerman, who didn't want the person he falsely assumed was going to commit the crime to get away before the police arrived. That, right, I'm going to underline that for a second because I want you to focus on that. Just a second. And I'm going to put in quotes, though it's not. Because what I want you to do is tell me how that fact that you swore to got into your affidavit.
Well, Zimmerman, on this affidavit, and there again, we're adding to what she had said in that paragraph, but given that, Zimmerman said he didn't want him to get away because they always get away.
So this thing right here, the falsely accused was going to commit a crime. Who made that determination?
It was the three of us throughout the process. I don't recall who did which sentence in this. This was not everybody sitting in one room. This was proofed, given to somebody else, and then prepared.
When the police dispatcher would realize Zimmerman was pursuing, he instructed Zimmerman not to do that, and the responding officer would meet him. Zimmerman disregarded the police dispatcher, continued to follow Martin, who was trying to return to his home. How do you know he was trying to return to his home?
Because the location he was found in is probably, and I don't have exact measurements, it's in the path to the back door of the house where he was staying.
I think the evidence suggested it was 70 yards away, right?
He came from there. I'm assuming he was going back there.
Okay. When you say he disregarded the police dispatcher, from your investigation, did he, at that point, hang up the phone and just do whatever he was going to do? Did he disconnect with dispatch?
He did disconnect with dispatch, but
I want to just try and keep us on the timeline. You had said, and now you've sworn to, that Zimmerman disregarded the police dispatcher, continued to follow Martin, who was trying to return to his home. Did he disconnect at that point? Do you remember?
no, he did not, because he can be heard walking, running
Stayed on the phone with the dispatch then, didn't
for
he
a
not?
short period of time. Yes, he did.
Zimmerman confronted Martin. Those words, where did he get them from?
That was from the fact that the two of them obviously ended up together in that dog walk area.
Right?
According to the witnesses, one of the witnesses that we talked with, there were arguing words going on before this incident occurred, but it was between two people.
Right. Which means they met. I'm just curious with the word confronted and how, what evidence you have to support an affidavit you want this judge to rely on that these facts are true, and you use the word confronted. And I want to now know your evidence to support the word confronted, if you have any.
Well, it's not that I have any. It's a word I used. I probably could have used 30 words.
It is an antagonistic word, but you agree.
It can be considered that, yes.
Come up with a couple of words that are less antagonistic. Met, came up to, spoke with.
Got in a physical confrontation with.
But as we are here today with you, with your knowledge of the case, you have nothing to support the confrontation suggestion, do you?
I believe I answered it. I don't know how much more explanation you wish.
Any you have, but you don't have any, do you?
I think I've answered the question.
Okay. Struggle ensued. That we at least have some what we call ear witnesses to hear some testimony concerning struggling, correct? So we know a struggle ensued. You have evidence of that, then?
Yes.
Witnesses heard people argue, sound like a struggle. During this time, witnesses heard numerous calls for help. Some of these was recorded. Trayvon's mom, Trayvon Martin's mother, reviewed the 911 calls and identified the voice, crying for help as Trayvon Martin's voice. Did you do any forensic analysis on that voice tape?
Did I?
Did you, or are you aware of any?
The Orlando Sentinel had someone do it, and the FBI has had someone do.
Is that part of your investigation?
Yes, it is.
And has that given you any insight, to the extent that you're aware of it, as to the voice?
No.
Did Trayvon Martin's mom identify that voice the second she heard it, or were there concerns with her ability to identify that voice?
I did not speak with.
You're aware of the investigation, are you not?
Yes.
So let me question you again to say, are you aware of any concern over Trayvon Martin's mother and her ability to identify the voice crying for help as her son's?
No.
Trayvon Martin was shot in the chest, correct? And he passed away?
Yes.
And Mrs. Zimmerman talked to police about the event, did he not?
Yes.
Didn't invoke his right not to speak to the police, did he?
No.
You can only ask that question if I know the answer is no. And he actually freely spoke to them, did he not?
Yes.
And of course, they recovered the gun, because Mr. Zimmerman did have a firearm with him, did he not?
Yes.
Registered to him?
Yes.
And he had a proper permit to carry it?
Yes.
And of course, the fired casing was found. From how many shots?
One.
Was there a suggestion along the way that there were 2 shots?
Yes.
Where did that come from?
One of the witnesses that lived in the perimeter area.
And of course, medical examiner determined that the cause of Trayvon's death was gunshot. Right?
Yes.
A moment, John. A couple more questions, if I might. Not related to that, so I'll stay here. My client called you, did he not, and offered to make a statement to you?
Your Honor, this is way beyond the scope of this, I guess.
Leeway allowed in bond hearing, so
I apologize.
we'll go ahead.
He did call you, did he not?
No, he did not. He called the state's attorney's office. However, I was present
I'm sorry.
during the conversation.
He called, you were there, offered to make a statement to you, law enforcement, state attorney's office. Do you recall when that was?
No,
3 days before his arrest? Would that sound about right?
within that time frame.
Okay. Do you have any information as to the ability of any other family member to either positively identify the voice on the 911 call as being Trayvon Martin's or not?
No.
How about the dad's ability to identify whether or not that was Trayvon's voice?
Dad? No.
You don't have any information concerning that?
No.
You're not aware of any inquiries that were made to Trayvon's dad as to whether or not he could identify that voice as being his son's?
No.
Then nothing further on.
Go ahead and proceed, Your Honor. And if Mr. O'Mara doesn't mind, may I use that same?
All yours, except for the, sorry for the blue marks all over it.
Mr. O'Mara talked about the first, I apologize. Mr. O'Mara talked about the first 2 paragraphs, I guess, being irrelevant. How long were you a detective in homicide for the Jacksonville Sheriff's Officer?
20 years.
And how about Detective Osteen?
I believe he was directly in homicide for maybe 6.
You guys have a total of how many years experience if you combine them both in terms of detectives?
As detectives alone and not in homicide?
Just like police officers. I'll leave it at
Police
that.
officers, probably in excess of 65, 70 years, almost to 70.
And in terms of, Mr. O'Mara asked you about the 3rd paragraph or the 4th paragraph in that affidavit. You, along with Investigator Osteen, had an opportunity to review other documents other than what's stated here, is what I'm saying, in terms of photographs, other stuff. Is that correct?
Yes.
And isn't it true, sir, that at least one witness described a person chasing another person in the back of that area where the murder occurred?
Yes.
Now, you were asked about this paragraph regarding on Sunday, that starts on Sunday, February 26th, that Mr. Martin was temporarily living at the residence there. He had a right to be there in that gated community, did he not?
Yes.
I mean, he wasn't, is there any evidence at all that he was breaking into anybody's house or committing any type of crime, sir?
No.
So he had the perfect right to be walking down the street that evening, did he not?
Yes.
And isn't it in fact true that, and you have verified that he actually went to that 7-Eleven store and bought some Skittles and a can of tea, did he not?
Yes.
And there's a video of that.
Correct.
And he paid for it. He didn't steal it or anything. Is that correct?
Yes.
And then he ended up walking back to the community. Is that correct?
Yes.
Now, the defendant, Mr. Zimmerman, also lives in that community, correct?
Yes.
And isn't it true, and we're relying on the 911 reporting where he said he called up the police and he stated, we've had some break-ins in my neighborhood and there's a real suspicious guy. He referred to Mr. Martin, did he not?
Correct.
And the defendant, Mr. Zimmerman, stated that it's raining, and so in his mind, he assumed or he profiled Mr. Martin as a criminal, correct?
Yes.
Because Mr. Zimmerman perceived that Martin was acting suspicious in his mind, in Mr. Zimmerman's mind, correct?
Yes.
And isn't the 911 report and the police dispatcher informed him that an officer was on the way and to wait for the officer?
Yes.
But isn't it true that Mr. Zimmerman did not wait for that officer?
Correct.
In fact, he continued to follow or to pursue Mr. Martin. Isn't that true?
Yes.
And during the reporting, there was mention of 2 quote marks. Those are actually the language, the words that Mr. Zimmerman used to describe Mr. Martin, or the people he felt were breaking into those houses, correct?
Yes.
And I'm not going to repeat the words for the purpose of the record, but they should speak for themselves. Isn't it true also that you verified through Detective Osteen, Investigator Osteen, that Mr. Martin was on the phone with a lady who was out of town?
Yes.
Okay. And in fact, that lady provided us more statement, but also you verified through phone records that that conversation actually took place.
Yes.
Okay. And what is described there in that next paragraph is accurate, that Mr. Martin was describing to the lady that he was scared because he was being followed throughout the complex by unknown male and didn't know why this male, Mr. Zimmerman, was following him.
To my understanding, yes.
Obviously, Mr. Martin didn't refer to the male as Mr. Zimmerman. I added that. I apologize.
Yes, and also this came from Osteen informing me of this. We had split work and had done different things.
And isn't it true that the route that Mr. Martin was going to, or I should say the 17-year-old young man was going to, he was going directly to where he was living, where he was staying. Is that correct?
Yes.
Okay. And isn't it true that this young man was unarmed?
Yes.
And isn't it true that Mr. Zimmerman was armed?
Yes.
And isn't it true that, in fact, in their reporting to the 911 or to the non-emergency operator or dispatcher, that you can actually tell when Mr. Zimmerman leaves the vehicle he's in and continues to pursue Mr. Martin?
Yes.
And isn't it true that the dispatcher or operator tells Mr. Zimmerman, hold on, and that's my word, but say something to the effect of, you don't need to be following him, and he still continues to follow him?
Yes.
And sir, you were asked about the next paragraph here, that Zimmerman confronted Martin and a struggle ensued. And you were asked a lot about what confronted means. If Mr. Martin was minding his own business and was going home, and somebody comes up to him and starts accusing him or does something to him, wouldn't you consider that a confrontation?
Yes.
That is, Mr. Martin didn't turn around and start, he was minding his own business, and Mr. Zimmerman is the one that approached Mr. Martin, correct?
Let me object at this point, Your Honor. Though great leeway is given, and I guess this is cross-examination, the concern is that he's talking now about evidence that is completely not in evidence.
What's the objection?
The objection is he is presenting facts that are not in evidence to a witness.
Why did you use the word confronted, sir?
Because Zimmerman met with Martin, and it was compiling the facts that we had along with the witness statements of the argumentative voices and the authoritative voice being given from one of the witnesses. and then the struggle that ensued that came from several witnesses.
But prior to that confrontation, Mr. Martin was minding his own business, is that correct?
Again, Your Honor, unfortunately, this is not in evidence, and he cannot present it that way to a witness.
Sustained.
Mr. Martin, the route he was taking was towards his house, correct?
Yes.
And he was unarmed.
Yes.
And there is no dispute. I know you didn't talk to Mr. Trayvon's mother, but she did state to somebody, I shouldn't say it to you, that the 911 calls she identified, the cries for help were of her son. Is that not true?
Yes.
Let me help out, Judge. And finally, sir, you were asked about that Mr. Zimmerman, the defendant, called the state attorney's office in an opportunity or something about talking. He, Mr. Zimmerman, was aware that the police were monitoring him, or Florida Department of Law Enforcement were monitoring the whole time he was out of town, right?
Yes.
Let me have a moment, Judge. I think I don't have any further questions.
Briefly, Your Honor. A couple of questions that were just asked you concerning the continued to follow, that Mr. Zimmerman continued to follow. What evidence do you have to support that?
When he was told not to follow him, he continued on for a period of time.
How long?
I don't know. I would say less than a minute before he hung up, which is prior to the encounter between the two.
Okay. Any other evidence besides that there was a phone call that he was on for a minute? Any other evidence? Any other witnesses? To the fact that he, quote, continued to follow?
We have a witness statement who observed, that was on the perimeter of this, who observed shadows or figures, running by her residence.
And do you know which way or who they were or anything?
I cannot identify who they were, but it was at the same time frame this occurred.
Okay. Besides that, any other evidence to support your conclusion that Mr. Zimmerman continued to follow?
Other than this call and that witness?
Yes.
And the fact that where it ended up, no.
Well, you do have some other evidence, don't you? You have Mr. Zimmerman's statements, don't you?
We have Mr. Zimmerman's statements, we have the shell casings, and we had Mr. Martin's body at the scene.
Let's talk about Mr. Zimmerman's statements to you and to law enforcement that night. Now,
You object as to hearsay. It's not part of the probable cause affidavit, and on purpose was left out. I apologize. I'm not trying to make an argument.
so, do you know who started the fight?
Do I know?
Right.
No.
Do you have any evidence that supports who may have started the fight?
No.
Mr. Zimmerman gave a statement that very night, did he not?
Yes.
And within that statement, he said that he saw somebody, he was concerned, he got out of his car, he called non-emergency, and began to go towards the person. Is that paraphrasing, but pretty correct so far?
Paraphrasing, yes.
Okay. And if I go wrong in this, stop me and let me know where I go wrong.
I will.
And then he said that he turned back around and went towards his car, did he not? In his statement.
In his statement, after he was told not to talk
Gotcha.
to the dispatcher, he says that he continued on to find a street sign.
Okay.
And then went back to his car.
Okay. So he said, before he knew anyone else saw or did not see what had happened, he gave a statement saying he went back to his car, correct?
No, towards his car.
Sorry, you're right. He went towards his car. Seemingly away from Mr. Martin, though, correct?
That part of the interview I don't recall because I don't know that he indicated where Martin was.
Did he tell you who started the fight?
No.
Did he give you any indication what happened?
No.
Not you, I apologize. Are you aware of any information of the statements that he had given regarding that?
Yes.
Okay. And in those statements that you're aware of and were part of your foundation for coming up with this probable cause affidavit, what did he tell the officers?
That he was the victim in this, and that it was Martin that confronted him and assaulted him.
When did he say that? When was the first time in relation to when the event happened? When did he say that?
The initial interview that was conducted at the Sanford Police Department.
How long after the event?
Within an hour and a half.
Had it been disclosed before he made that statement, any information about what other evidence the police had gathered regarding this investigation?
You mean to him?
Yes.
Not to my knowledge.
Would it be safe to assume then, in him giving that statement to the police, wherein he said, one, I turned around and went back to my car, and two, that he did not start the fight and that he was assaulted by Mr. Martin, when he gave that statement, did he have any indication that there were or were not half a dozen witnesses who saw the whole thing?
I have no knowledge of that. I don't know what.
Any insight you can give us as to. Okay, sorry.
I have no indication of what he picked up from other officers at the scene. I know from reading reports there were witnesses gathered around while he was still at the scene, and this was prior to their having statements taken from them. So I don't know what he picked up from overheard conversations.
That statement that he had given you given law enforcement that day, that we just talked about, turning around and that he was assaulted. Do you have any evidence in your investigation to date that specifically contradicts either of those two pieces of evidence that were in his statement given several hours after the event?
Which two particular
That he
cases?
turned back to his car. We'll start with that one.
I have nothing to indicate he did or did not do that.
My question was, do you have any evidence to contradict or that conflicts with his contention given before he knew any of the evidence that would conflict with the fact that he stated, I walked back to my car, walked towards the car?
No.
No evidence. Correct?
I'm misunderstanding. Are you talking about at that point in time?
Since today. Today. Do you have any evidence that conflicts with his suggestion that he had turned away and went back to his car?
Other than his statement? No.
No. Any evidence that conflicts with that?
He answered it.
Okay.
He said no. Is that correct?
Any evidence that conflicts, any eyewitnesses, anything that conflicts with the contention that Mr. Martin assaulted first?
From that contention that was given to us by him, other than filling in the figures being one following or chasing the other one as to who threw the first blow, no.
Okay. Now, you know, as one of the chief investigators, that is the primary focus in this case, is it not?
There are many focuses in this case.
That would be considered the primary, would it not? In your opinion, 35 years experience?
I don't know that it's primary. It's one of the concerns, yes.
Nothing further.
Mr. Gilbert, I didn't know we were going to be trying the case, so I'm going to add I apologize. I'm going to add some questions to, you have reviewed, or other members of the team have reviewed his interviews. Is that not true? That is, and the defendant, gave numerous interviews to the police, did he not?
Yes.
Okay. And isn't it true that a lot of the statements that he made do not make sense in terms of the injuries that he described? Did he not describe to the police that Mr. Martin had him on the ground and kept bashing his head on the concrete over and over and was physically just beating him with his hands?
He has said that, yes.
And isn't it true that there's evidence that indicates it's not true?
Yes.
Did he also not state that at some point, he, the defendant, did he not state that, or claim that the victim in this case, Mr. Martin, put both hands, one over his mouth and one over his nose so that he couldn't breathe?
Yes.
And that all of a sudden, that's when he was able to get free and grab the gun, or I'm sorry, Mr. Martin was grabbing for the gun. Did he not claim that too at some point?
Yes.
But, and I'm not going to get into every little contradiction, but wouldn't you agree that a lot of his statement can be contradicted by the evidence, either witnesses or just based on what he says himself? I apologize, Your Honor, if I may have. Did he, Mr. Zimmerman, the defendant, at one point claim to the police that he was scared because Mr. Martin started circling his car?
Yes.
But despite, according to Mr. Zimmerman, he was so scared, he still got out of the car and chased Mr. Martin, correct?
He went after him, yes.
And is it not true, based on the evidence, that Mr. Zimmerman, the defendant, also had two flashlights with him?
Yes.
Okay. One was tied to his key, and the other one was just a smaller or bigger than the other one. But what kind of? How would you describe that kind of flashlight? What is it?
I would refer to it as a tactical flashlight. It's larger than the small one that he had with his keys, but it's probably 6 inches long.
I do have another question to you on.
I apologize.
Oh, I thought you said you were done. I'm sorry.
I apologize.
Sorry.
My fault.
Lots of time to make sure they can talk to their respective.
I just didn't hear that. Sorry.
Mr. Zimmerman never claimed that he chased, in terms of ran after Mr. Martin. Is that correct?
No.
But you still have, is it not true, a witness who describes someone chasing another person from the area where they ended up? In other words, from near where Mr. Martin lived to the area where the murder happened. Thank you.
Before you ask yours, I have a question. Any evidence with respect to how far the individuals were from each other when the shot was fired?
It was close proximity. There were powder burns on the sweatshirt, near contact on that, and there was also stippling on Mr. Martin to indicate it was close proximity.
Thank you.
Thank you, Your Honor. You had mentioned, I believe, prosecutor had questioned you about Mr. Zimmerman saying that he was having his head hit on the back, correct?
Yes.
And I thought you said that the evidence was inconsistent with that?
No, I don't believe that was his question.
Oh, then let me ask you. Is the evidence inconsistent with the suggestion by Mr. Zimmerman that he was having his head hit or bashed on the ground?
His injuries are consistent with trauma to the back of his head, yes.
Okay. Well, what are those injuries?
Pardon me?
What are they? Tell us
the
about
injuries?
them. Yes.
There's 2 lacerations to the back of his head.
Okay. Did you identify what caused those lacerations? Could it have been from having his head bashed on the ground as he testified to?
He suggested, I don't know, testified to.
I'm sorry, told you about.
He mentioned that, excuse me, that his head was being physically bashed against the concrete sidewalk, and that this was just prior to him firing the shot, and that he managed to scoot away from the concrete sidewalk, and that is, at that point, is when the shooting subsequently followed. That is not consistent with the evidence we found.
The injuries seem to be consistent with his story, though, don't they?
The injuries are consistent with a harder object striking the back of his head than his head was.
Could that be cement?
Could be.
Okay. Did you just say it was consistent, or did you say it wasn't consistent?
I said it was.
Okay. Have you ever had your nose broken?
Pardon me?
Have you ever had your nose fractured or broken?
No.
You know that that was an injury that Mr. Zimmerman sustained, correct?
I know that that is an injury that is reported to sustain. I haven't seen any medical records to indicate that.
Have you asked him for them?
Have I asked him for them? No.
Do you want a copy of them?
Sure.
I'll give them to the state. It's a more appropriate way to do it. If you haven't had them yet, I don't want to cross you on them. Nothing further. Thank you, Your Honor.
I don't know if further questions, Your Honor. Just for the speak, excuse me. Yes, sir.
Yes, Your Honor.
State. Yes, sir.
Thank you, sir. Your excuse. Anything further, Mr. O'Meara?
No, thank you, Your Honor.
Mr. Larianda, anything further?
No, Your Honor.
My client wants to make a statement to the court, Your Honor.
Sworn in, please.
Do you solemnly swear affirm the testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God?
Situated, sir, if you'll please state your full name for the record and spell your last name.
Michael Zimmerman, Zimmerman.
I do think an inquiry is probably appropriate by the court, just to clear up the issue that he is a criminal defendant facing second-degree murder charge, Your Honor, and that anything he says, I want to make sure that he's aware of it, and so we're clear. I've discussed that with him.
George Michael Zimmerman.
And you had advised me that you wanted to make a short statement. Is that correct? Correct.
I wanted to say I am sorry for the loss of your son. I did not know how old he was. I thought he was a little bit younger than I am, and I did not know if he was armed or not.
And I'm sorry, sir, you're not really addressing that to the court. You're doing it here to the victim's family. Is that correct?
They are here in the court, yes.
I understand, but I thought you were going to address Your Honor, Judge Lester, not. So that's really addressed to the family and where the media happens to be, correct, Mr. Zimmerman?
No, to the mother and the father.
Okay. And tell me, after you committed this crime and you spoke to the police, did you ever make that statement to the police, sir? That you were sorry for what you'd done or they're lost?
No, sir.
You never stated that, did you?
I don't remember what I said. I believe I did say that.
You told that to the police?
In one of the statements, I said that I felt sorry for the family.
You did?
Yes, sir.
So that would be recorded because all those conversations were recorded, right?
Yes, sir.
Okay. And you're sure you said that?
I'm fairly certain.
Okay. And so which officer did you tell that to? You gave 5 statements, I believe, total.
Yes, sir. I'm sorry. All the names blend together.
Okay. And do you remember if it was a male or a female?
There were both males and females.
At the time you made that statement that you were sorry?
Yes, sir.
And let me make sure the record's clear. You stated exactly what to those detectives?
I don't remember exactly what verbatim.
Okay. But you're saying you expressed that concern for the loss of Mr. Martin, or that you had shot Mr. Martin, that you actually felt sorry for him?
I felt sorry that they lost their child, yes.
And so you told detectives that you wanted them to convey that to the parents?
I don't know if they were detectives or not.
Officers, I apologize.
I didn't know if they were going to convey it or not. I just made the statement.
Okay. And then you said that you called them up or you left a message for them to tell them that?
No, sir.
Why did you wait 50-something days to tell them, that is the parents?
I don't understand the question, I'm sorry.
Why did you wait so long to tell Mr. Martin and the victim's mother, father and mother, why did you wait so long to tell them?
I was told not to communicate with them.
Okay. So even through your attorney, you didn't ask to do it right away? Your former attorneys or anything?
I did ask them to express that to them, and they said that they were going to.
But before you committed this crime on February 26th, you were arrested, or you were, I'm sorry, not arrested, you were questioned that day, right? February 26th.
That evening and into the 27th.
Sir. And in the following morning,
Mm-hmm.
Is that correct?
Yes, sir.
And in the following evening, too?
Yes, sir.
Okay. Would it be fair to say you were questioned about 4 or 5 times?
I remember giving 3 statements, yes, sir.
And isn't it true that in some of those statements, when you were confronted about your inconsistencies, you started saying, I don't remember?
Outside the scope of direct examination, I would object, Your Honor.
Give them a little bit of leeway, not a whole lot, but a little bit here, okay?
Isn't it true that when you were questioned and you were questioned about the contradictions in your statements, that the police didn't believe it, you would say, I don't remember?
I'm going to grant his motion this time.
Thank you, Your Honor.
Would you agree that you changed your story as it went along?
Absolutely not.
Okay. Now, sir, you had a phone when at some point, and you agreed to turn over that phone to the police so they could make a copy of what was in there, right? Okay. And in that phone, did you receive or send text messages, sir?
Yes, sir.
Okay. Did you ever make any reference to a reverend?
Object, Your Honor, outside the scope of direct.
Sustained.
Did you ever make any reference to Mr. Martin, the father of Mr.
Sustained.
of the victim?
I'm getting a little bit far away.
I apologize. Your Honor, my question is, he was asked in terms of apology to the family, and I'd like to be able to address that if I could.
I think you can classify it as whether or not he asked the apology. I don't want to get into other areas perhaps.
Yes, sir.
Thank you.
My question is, Mr. Zimmerman, do you recall sending a message or to someone, an email about referring to the victim's father?
No, sir, I don't.
And just to anticipate, I guess, is the court ruling that I can't ask him about his statements he made to the police in terms of his limited testimony. I just want to, before I get that, I don't want to be trying to ask the question and objections being made.
You've already anticipated, and you anticipate my ruling too.
Thank you very much, Your Honor.
I have no further questions, Your Honor.
Thank you. Step down.
No further presentation.
State anything further?
No, sir, not witnesses.
Argument?
Yes, Your Honor. Though there is a presumption against bond initially with a felony like this, in order to maintain that, the state would have to convince you to a standard that I don't think they attempted to reach today, that being what we know commonly as the Arthur standard. I think then he is entitled to a bond. The question then becomes what conditions of release would be appropriate to do, what bond is supposed to do, to assure his appearance back at trial. To that end, we do have some prior criminal record. We have, in your further testimony, an event where it seems as though he may have been, in his mind, coming to the aid of a friend, led to his arrest for a couple of felonies, dropped down to misdemeanor. Pretrial diversion, as you know, and we all know, anger management is a condition of all pretrial diversions in those regard, not necessarily specific to my client, but he did successfully complete that. The injunction is in record. I almost invite you to review it because I think there's good information in there as to how he acted and failed to overreact with some of the events that happened. But what he did do was use the court system to get an injunction against her. They stayed away from each other, and nothing's happened since. And of course, there was no criminal event, even though she called 911 and suggested some type of a battery. So as far as his prior record, that's it, and I would suggest it is, in fact, as I mentioned earlier, minor. As far as his financial abilities, unfortunately, this is a family of very short means. You've heard Mom and Dad testify that they are willing to assist by securing their house. Whatever we can accomplish, we certainly will. I will tell you that I truly don't know the specifics of some fund that's out there that's not being administered by me. I don't know what the amount is, but when we look to the assets and financial picture of my client, we know, one, unfortunately, based upon these circumstances, he will not be able to work in public in the near future, so he cannot support himself. He has a wife who's not working presently because she's in school. I'm asking you to consider a reasonable bond in the amount of $15,000 that will secure his appearance, and there are other conditions. Certainly, with a case like this, I'm also going to ask you to allow Mrs. Zimmerman to leave the state. Further, I'm going to ask that you maintain an extraordinary level of confidentiality and secrecy over his whereabouts because of the potential danger that exists in this case. That can be accomplished by the use of a GPS monitoring device. I've been in touch with Seminole County. I would have brought them, but they would tell you information that I know you already know, which is that GPSs are nationwide now. They are secure. We will know quickly if he is not in the location he is. We have surrendered his passport. He doesn't have a legal way to get out of the country, though there are always illegal ways, I suppose, for people to get out of the country. We then need to look at what Mr. Zimmerman has done during the time this event has been pending. As proffered by the state, my client stayed in constant contact with Florida Department of Law Enforcement, letting them know exactly what was going on and literally building a trust relationship with FDLE such that when they said to come in, though the active warrant wasn't identified, and I don't fault FDLE, they did exactly what they should do to secure the safety. He came in voluntarily and surrendered himself to law enforcement. He is well established in the community, 10 years, though he cannot stay in this community. He had a job that he was doing quite well at for a long time. He was able to support himself. And I must back up. You have no testimony concerning his employment, and I apologize. Can't be considered. But certainly, when we look at this case, I would suggest that Mr. Zimmerman's situation suggests a bond. And the inquiry concerning the probable cause affidavit was for that particular purpose. If the state is going to say to you that this is a second-degree murder case, because I say it is, and that is what they present to you as evidence of second-degree murder, then I would ask that you consider the anti-author argument, which is not only could the state not prove this case to the author standard, that proof is evident and presumption great, but that as of today, you and I know now more about what happened or may not have happened that day, and I ask you to consider that in considering whether or not you'll allow a bond and then the amount of it.
Thank you, Mr. Ware. Mr. De Leon.
May it please the court. Your Honor, obviously we differ, and I know the court may be in somewhat of a disadvantage because we haven't tried the case. And the way what occurred here maybe was an attempt by defense counsel to try it in terms of just the probable cause, but we obviously have much more than that. But our position is that the court should consider in terms of what he is facing, that is life in prison. And so it's a felony, a life felony, and that obviously makes it different than what he was before in terms of when he was out. He wasn't charged with a crime in terms of his flight risk. You also have the fact that it is an unarmed 17-year-old boy. I mean, the court has to consider the fact itself. This young man was minding his own business, was not committing a crime. And I know we're not going to litigate the case in front of the court at this time, but that is a factor in terms of you have an innocent young man whose life is no longer among us. His ties to the community, I don't know how good they are, quite frankly. I think he's got a nice family, but, you know, where's he going to stay if the court lets him out? And will he be a threat to other people? Will quite frankly, some people may want to get at him, in fairness to him, in fairness to the defense. But our position is that you have a person, Mr. Zimmerman, who in the past has committed violent crimes. Now, it was minimized, I guess, by the fact he was allowed to in some diversion program, but it shows a lack of adhering to authority, which I think is an important factor. The court is obviously the most authoritative figure in this courtroom, and for this case, but you had a law enforcement officer who told them to abide by his commands, and he just disregarded it. And as a result, he confronted that officer, and now I guess through the family they're saying, well, some kind of self-defense or something, he didn't really mean to do it. But the bottom line is you have a prior violent act, and then you have the consideration of the injunction. Granted, he did end up putting an injunction, but meaning he has prior violence in his past. So it's not somebody who's never been in trouble with the law before. And I think the court has to factor that in terms of consideration of the safety of the community. He's has violence in the past, and then obviously he committed this crime, or he's charged with committing this crime. I know the court hasn't heard all the facts, so the court can't adjudicate him at this time. Our position is that he still will be a danger to the community, and based on the crime, he should be either kept on no bond or the bond should be $1 million, quite frankly. We feel that we've established at least probable cause, if not more, based on the facts. I mean, what it boils down to, he shot somebody. Now, his defense is, which is an affirmative defense, which he's obligated to put, and which there's no evidence to the court of that right now, since the court, obviously, the defense chose not to ask Mr. Zimmerman about that, nor was I able to inquire of him. So quite frankly, that is not before this court. The facts before this court is you have a 17-year-old young man who was minding his own business and was walking home when he was confronted by the defendant, who felt that Mr. Martin was committing a crime of some type. Unfortunately, he made the wrong assumption, and that's why the word profile was used for no other way. That's the reason the word is there. And he confronted Mr. Zimmerman. Why else would he confronted Mr. Martin. Why else would Mr. Martin want to confront Mr. Zimmerman? Mr. Martin was on his way home, minding his own business. If anything, you could argue that the self-defense is really Mr. Martin trying to defend himself. But I'm not here to argue all the facts, obviously. Our contention is, Your Honor, that this is a serious crime and that he should be held under no bond, or if the court were to set a bond, it would be $1 million. And I thank you for the court's involvement.
Thank you. Anything further, Mr. Mayor?
I have numerous cases to present, but
I'm familiar with case law.
I was going to say, Your Honor, you are more familiar than I, so I'm not going to bore you with those. I just ask you to consider the case law and make a determination.
Thank you very much. The good thing about practicing law in Florida as a judge, as a prosecutor, and a defense attorney is that we have lots of experience. I don't think there's too many other jurisdictions in the country that get the wealth of case, the amount of cases like this, not this particular one, but just cases in general in the criminal justice system. So we're all very experienced with it. This is a very common type hearing, and we're all familiar with this type of hearing. It's a regular hearing, but for the media involved in this particular case. And the circumstances associated with Mr. Zimmerman's record are something that the court and anybody who practices here in the Central Florida area is familiar with the situations that goes on at those establishments on the UCF corridor is the way I'll describe it. I think that's the best way. And so we're familiar with those particular situations. It's, I won't say a standard, but it's a run-of-the-mill type run-in with the alcohol beverage agents there at the library, I believe it was. Is that correct? At the library. They're fairly common, so I'm familiar with those, even though it's in another jurisdiction. The injunction was somewhat mild compared to the injunctions that I'm familiar with, and so really what this revolves about is the facts of this particular situation as presented to the court. What I'm going to do is I'm going to find that the motion is well taken. I'm going to grant the motion, set bond in the amount of $150,000 with the following conditions: electronic monitoring, GPS. I'm going to require the state and the defense to meet with the sheriff's department to accomplish that. That means that Mr. Zimmerman is not going to be released today, but I'm going to make sure that the state and defense can work out those assurances. And then if we need further hearing, again, to preserve the secrecy and to establish safety, as long as the state and defense can agree, that's fine with me, and the sheriff's department agrees, that's fine. If we can't, we can have another meeting with respect to that. There's to be no contact directly or indirectly with the victim's family or through an intermediary in any way. There is to be no possession of firearms, be they rifles, shotguns, handguns, pistols, revolvers, any type of firearm or destructive device. There's to be no consumption of alcohol. There's to be a curfew from 7 o'clock p.m. till 6 o'clock a.m. He is to advise the monitoring supervisor and the sheriff's department as to his location every 3 days. Are there any other special considerations the state wants me to invoke at this time?
Your Honor, we would request that he, obviously his attorney has a right, but have no contact with any of the witnesses in this case. And in fairness to Mr. O'Mara, he doesn't know who the witnesses are at this time, but...
Contact with the witnesses.
Understandable.
He can actually go and meet with Mr. O'Mara. That's between Mr. O'Mara and his client, how they're going to arrange that, and due to the facts of this particular situation. Anything else you want me to consider?
No, Your Honor.
Okay, no use of controlled substances other than those lawfully prescribed to you by a licensed medical doctor. I mentioned no consumption of alcohol. Mr. O'Mara, anything else you need me to consider?
I'm asking that Mrs. Zimmerman be allowed to reside out of state, Your Honor.
And that's why I'm saying you need to talk with the state, you need to talk with the sheriff's department, work that out to see if it can be accomplished, and then if there's further discussion, you can bring it before me, okay?
Yes, Your Honor.
All right. There were some other issues. I think yesterday the press was somewhat concerned that we were holding the hearing outside of their presence. I think by virtue of the order that I entered, they saw what the purpose of that meeting was. It was purely for logistical purposes, to figure out how to get Mr. Zimmerman dressed for the hearing and how to secure the appearance of the witnesses in a manner which preserve their safety. The state has indicated that they're very concerned about that with respect to their witnesses. The defense has indicated they're very concerned with that with respect to their witnesses. In light of that, I'm going to have to work, and I'm going to rely upon the state defense to assist me as far as what to do with the court file, because the media absolutely has a right to the court file. The state understands that. The defense understands that. I think at a preliminary, we need to work toward getting that information to the media with a redacted version as far as addresses and names. And state defense advised me if you have any objection with me working toward that right now, I'll give you the final product so you can okay it before anything's released. We can get that to the media as quickly as possible, and then we'll tentatively set a hearing for next Friday at 9 o'clock to allow the media to go ahead, and if they have any other further concerns at this time, to go ahead and voice them then. But I think if we can get that product to them immediately, I think that will alleviate a lot of the concerns they have with not being kept up to speed and being involved in the case as far as file. Is that okay with you?
Your Honor, in fairness to, if I may address the court, in fairness to defense counsel, I have not provided him to discovery, and I think, quite frankly, that doesn't trigger it until I provide Mr. O'Mara discovery. And I don't know, I know Mr. O'Mara and I had spoken before. There's some issues that I think both sides, I know I will concur with Mr. O'Mara, should not be subject to the public knowing about, including statements, et cetera. And I think we could address those with the court at a later date.
I think what we can do there, Mr. O'Mara, if you agree that you two can work it out, and if you think there's an area for concern, you can go ahead and approach the court by motion. We can have that heard, and then we can discuss it. But with respect to what's in the file here today, it's fairly thin as far as...
Understood.
I apologize. I agree as to what's in the file right now. I apologize. That's correct.
My only concern, yes, I agree. Working towards that goal is good, and we need to get to it quickly. I had gotten or received some notice of hearing that told me of a hearing before a circuit judge Tuesday at 9 o'clock on motions filed by the media.
I don't know about that, but I'm just telling you that I'm more than happy to. Most of the file consists of motions filed by the media, by the way, so you can look to your own files if you want to do that. But I think the best way to get it is for me to work through this, give you the product, both of you, all the attorneys look at that, make sure I'm okay, get that to them as quickly as possible, and then if they have any further concerns, we can address it at that hearing on Friday at 9 o'clock.
And we don't need to be here Tuesday at 9?
I'm not holding a hearing at Tuesday at 9. I still have a working division. I'm still doing other trials. The state attorney's office has thousands of cases up in Duval County. You have an active practice. That's it.
Thank you for the extra time.
Thank you. Anything further from the state at this time?
No, thank you very much.
Anything further from the defense at this time?
No, thank you, Your Honor.